SchnitzelNinja!
Hey guys, it is Schnitzel. I wanted to make a video covering this designation of record on appeal, which is something Laura filed in the DVRO renewal case against Mike Maricini, the case that was dismissed and she will not let go of. I'm going to cover these fees that she paid to get some documentation for her appeal, which the designation of record on appeal is for. We're going to go over the trustee's application for an attorney, which was granted in Laura's Chapter 7 bankruptcy case. And we'll take a quick look at Laura's actual bankruptcy filing. We're going to take a look at the new Laura Owens, Justice for Laura Owens website, justiceforlaura.com, that she totally didn't make herself. And we're going to look at a little information about that website. So let's start here at the designation of record on appeal. As you guys recall, I'm sure, on June 10th, approximately, Laura filed to renew her DVRO, domestic violence restraining order, against Mike Maricini. She was requesting a permanent restraining order from the renewal. As we know, Laura was able to have the first set of hearings of the trial continued for 2 weeks due to ADA accommodations. Then Laura did not show up for the second date for the trial, which was November 5th. And because of her absence, the judge dismissed the case. Laura has decided to appeal that. She has not filed her appeal brief yet, but everything she's done since then looks like she's planning to do that. Now, one of the steps for filing the appeal is to file this designation of record on appeal. I have this here. It talks about the steps in California, specifically in San Francisco, for the San Francisco Superior Court, where this case was handled. It talks about all of the different steps you need to take to file the appeal. And I have reference links here as well that is where the information's pulled from. So first, which she's already done, you have to file the notice of appeal. The deadline for that, and she was within the deadline. So this is all well and fine, just going over the steps. So you have 60 calendar days after service of notice of entry of the order you're appealing. So November 5th, she had 60 calendar days after November 5th to file the notice of appeal, which she did. Step 2 is what she has done, which is file the designation of record on appeal. Now, we know she also filed the motion to correct and augment the record, which isn't, a standard or required step, but as I talked about in my last video, she was doing that to try to get things on the record that wouldn't otherwise be on the record and wouldn't be able to be referenced or used in her appeal. So this designation of record on appeal, it's basically, it's saying these are the things that I want to have the record reflect, to be able to use these things in my appeal. So it's like certifying the record in a sense. Now, to my understanding, it normally is pretty straightforward with what would be on here. maybe where an issue would come up is a certain exhibit or something like that. But Laura in that other filing is straight up trying to ask for things that aren't actually a part of the record. So, while she filed this and it's standard to file it and required to file it, some of the things she's asking for are like ridiculous. So, anyway, this you have 10 calendar days after filing your notice of appeal. And she was within that. It didn't show up on the court docket for a while. Um, did I bring that up here? Yeah, on the so it didn't come up until I think January, like not too long ago. But it was actually filed on the 18th. So you can see she filed it within 10 calendar days. Here's the notice of appeal that when she filed it, December 9th, and then the designation of record on appeal. While we didn't see it for a while, it was filed on December 18th, so that's within the 10-day limit. So this step 3 is optional respondent's designation of additional record. Now here's where Laura's appeal is interesting, is that her issue is with the court. Her issue isn't with anything that was argued or anything that was presented by the respondent, by Mike or Omar or the rest of the legal team. So, respondent is Mike, but there's not really anything for Mike's side to add here or include here or even respond to. We kind of have to wait and see how the court handles this. At the hearing, I know we don't have a recording of it, and to my knowledge, it's not available to like request and distribute publicly. But Mike's side didn't really say much of anything, and I know I've talked about this already, but they basically introduce themselves. The judge is like, she's not here. This is going to be a quick hearing. And she says, Judge Gold says, I'm dismissing the case. Omar says he's going to submit an application for attorney fees and costs. And that was pretty much it. That's pretty much all that Mike's side said. So there was really nothing on record from November 5th that Laura can argue, because they didn't argue anything. They didn't argue anything in her absence. So yeah, this we probably won't get unless for some reason the court like asks them to respond. I know I'm not a lawyer, I'm not an expert on this, but that's the only way I can see is if the court invites Omar and Mike to respond here. So file civil case information. It says this is step 4. This is 10 to 15 calendar days after the Court of Appeal clerk mails the CCIS, the Civil Case Information Statement notice. So that is on the court. That's a court thing. Then after that, we would have the appellant, so Laura's opening brief or her appeal brief. So this is usually 40 calendar days after the appellate record is filed in the Court of Appeal. So we have, a step or two to go really before this counter starts. I don't see this section of proceeding with an appendix. Obviously we don't know exactly what she's filing yet, but I think it would be this 40 calendar days after the appellate record is filed in the Court of Appeals. And again, that's something the court handles, is filing that. So again, here's a timeline for opening brief that these things are referencing. Respondent's brief, again, technically Mike is the respondent, but Laura's issue is really with the court. Judge Gold shouldn't have done this. She shouldn't have held the hearing. Um, blah blah blah. Whatever, crazy stuff she's gonna try to cite in there. She could reply. So it'll be interesting to see. I don't know how. And people I've spoken with aren't exactly sure how the court is going to handle this. Um, if the court itself is going to respond, if Judge Gold will respond, we just kind of again have to wait and see how the court decides to handle this whole thing. Um, and then just as in Clayton's case, if the Court of Appeal had granted like an oral argument, that would happen. That would be kind of like the last step before the Court of Appeals ruled on the appeal. So we go back to this designation of record that Laura filed on the 18th of December. Appellant Laura Owens hereby designates the following documents and transcripts to be included in the record on appeal from November 5th, 2025 dismissal. As we have talked about before, there are some things in here, like this motion to proceed by declaration and waive live testimony, that Laura did not file properly. I cannot attest to why it wasn't filed properly. At this time, I can just let you know that it wasn't filed properly. Okay, so this is, I think if we were to look at the docket, this is most, if not all, of everything that you would see here. If we go back, gosh, it's gotten long since July, hasn't it? Anyway, all of these things that we saw, Laura filing the renewal, the requests. I don't know. I don't remember if she put. Probably none of Gingriss's stuff is in here. The things that he filed on his own. So she wants to include the request to renew the restraining order filed July 9th. I also wanted to mention she'll say somewhere in here that, she has e-served Mike and Omar. The funny thing to me is that on the October 10th, in the October 10th hearing, Laura made an issue with the fact that she didn't consent to being e-served. There was something around that. And it goes both ways. It was kind of a verbal, from my understanding, agreement. And then she tried to make this whole thing with the court because of, I think it was the serving of the, oh gosh, what was it called? Where they were going to, try to fight the original ruling, 473B. So anyway, she talks about how she has e-served Mike, but you can't have it both ways. So she has e-served him, and that's not like she needs to send it by mail if it's going to be properly served, which to my understanding she hasn't done. I also wanted to point out, as I'm remembering now, Laura never sent Mike or Omar her exhibits for the hearing. Now, like, I was talking with someone and they said, if they showed up on November 5th and she was actually there, they mailed her like certified copies of their exhibits and a thumb drive. So she had it electronically and she had physical copies. She sent them nothing. So if she had shown up either virtually or in person on November 5th and said, "Oh, here are my exhibits," that would have very likely been okay. So they wouldn't have been able to review them beforehand, but likely the hearing would have continued. I just find it, personally, I find that very interesting, as in, like, we all know she wasn't going to go anyway, ever. Maybe unless she had a lawyer who would actually represent her, but that she never sent any of that information over to them. And because it was never argued in court, none of that stuff is, I mean, some of this stuff is a part of the official court record, but nothing, we don't have actual exhibits. It's just like in, similar to the 2018 DVRO, they entered an agreement. So none of the stuff that was presented or submitted actually became exhibits because it was never argued in court. It's the same with this. While there wasn't an agreement, it was dismissed. So nothing was argued. So none of this stuff is, nothing is an actual exhibit, which I think is kind of unfortunate. So, okay, so request to renew restraining order filed July 9th. So that's a day before it was set to expire. Notice of hearing to renew restraining order, procedurally, yeah, that makes sense. Order to reschedule hearing to renew restraining order. Declaration of Laura Owens in support of request to continue hearing. It's not unheard of to try to continue these, but I just think it's kind of funny. Like the court mentioned in this October 10th hearing, when she tries to get Laura tries to get the trial continued, and that's another thing, she didn't file properly, so it wasn't before the judge. But they brought it up. She brought it up. Laura did, and the judge says basically, like, you're the one who brought this case to the court. You should be, out of anyone here, you should be prepared. So, like, you need to get your shit together in the next 2 weeks because this hearing is happening. So, we can only, it can be conjecture as to why she requested the continuance. I mean, I have my thoughts and opinions on that. Motion to proceed by declaration and waive live testimony. This also was not properly before the judge, and in the October 10th hearing, this was mentioned because Laura told the judge she really didn't want to show in person. She wanted to, like, she had, submitted this, and to my recollection, the judge says this wasn't before her, so she was not aware that Laura had wanted to do that, to waive the live testimony and proceed by, like, on paper, basically, to just write down a declaration and submit that. And the judge said, no. She said, you have to be here in person. It's Mike's right to confront her in court. And Laura tried to say, oh, well, these other two guys that I have orders of protection against, they're going to be there. And the judge was like, okay, we have security. Like, you're going to be fine. You need to be here. Respondents' response to request to renew restraining order. So that's Mike's filing. Ex parte application for continuance of hearing. That's the one that Laura filed that was, like, not before. I know there are a lot of them. Can get them confused. But the one that wasn't before the judge, that was addressed in the October 10th hearing and not granted. Declaration of Laura Owens in support of ex parte application for continuance. That goes along with number 7 there. Expedited request for reconsideration of motion to continue based on urgent health concerns. Declaration of Laura Owens in support of expedite. Okay, so that's just her declaration to go with it. Notice of hearing renew restraining order on October 22nd. Continue to November 5th. Reasonable accommodation. Reasonable for someone who actually needs it. Then the mini minutes from that hearing. And if you guys remember, the initial hearing was set for, the first day was set for October 21st. Laura did not show in person, but she did appear virtually. The judge told her, you need to get here tomorrow. I told you to be here. And since, it's interesting, it's kind of a blessing and a curse that they had 2 days for this hearing. And, who could predict also the blessing and a curse, because the judge said, since we have 2 days, I'm going to give you today to get here for tomorrow. And then Laura pulls out of her ass these ADA accommodations. That's why it's a blessing and a curse. The blessing is that they could have had 2 full days to litigate this issue. I can't remember the other thing I was going to say about that. Maybe I'll remember it. Mini minutes for October 22nd. So that's the second day of trial. Oh, I was going to say, who could have predicted the other random issue of there not being a court reporter available. That was the other thing that was, you know, if Laura didn't waive the uh, a court reporter being in the room or there virtually, the attendance, if she didn't waive the attendance of a court reporter, then the hearing could not have happened anyway. But for that second day, October 22nd, Omar and Mike had hired a court reporter who was certified and approved by the court, not a member of JFC. So that second day, it wasn't an issue. But again, overnight, Laura does this ADA request, and it's granted, which it should have been, because if someone really needs that, but you know, and this, if someone really needs that, they should get it. But this is what Laura does. She abuses the court system. She figures out all the different loopholes she can use, and she tried one on November 5th, or you know, leading up to November 5th, and was unsuccessful. And I'm sure that pissed her right the fuck off. And I love that for her. Number 13, proof of service by electronic mail by the court. So, proof of service, I'm not sure exactly which one that is. Maybe that's something that she submitted electronically, or I'm not quite sure. So I won't guess. Order on media request to permit coverage denied. So what would be a reason she wants this included? She's probably going to try to talk about the JFC cult, the harassment, blah, 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 same old story. It's fine if people want to follow a case and that people have an opinion on a case. And it's fine if people want to expose the lies. That's not illegal. And it's not harassment. Many minutes from November 5th. Notice of hearing a renew restraining order on November 5th. Dismissed. So the mini minutes, and again, that it's dismissed. Maybe this is, I don't think I've seen this. It might just be saying that it's dismissed. DVRO on November 2025 dismissed. Motion to correct and augment the record. That's the last thing she had filed before this filing. The declaration for that she wrote. The notice of appeal that she submitted the next day. Clerk's notice of filing, notice of appeal. So it looks like the clerk did send that on to the appeal court. Register of actions, entire docket as of December 14th, 2025. And I, from what I understand, again, things can show up on this docket, but that does not mean they were filed properly. And ideally, they wouldn't show up on here if they weren't filed properly. But if we can remember back during this time frame, not necessarily these dates we see here, but July through November, there was a lot of turmoil at the San Francisco Superior Courthouse with the court clerks, and they were actually set to go on strike the morning of trial. And they came to an agreement before that happened with the court. So one of the things I remember they were complaining about was like the lack of training or lack of time to train someone new. So long story short, there were things during that time that made it to the docket here that we were able to request that shouldn't have been, and are not official, if that makes sense. So I don't know how that plays into the register of actions. You know, if the court is going to look at that and say, oh, well, this wasn't filed properly, that wasn't filed properly, so these aren't, you know, actually technically supposed to be on the register of actions. That's something I just don't know, and we'll have to see what happens. So that was all A. This is B, reporter's transcript. Appellant designates the reporter's transcript for the following hearing date, November 5th, 2025. If a reporter's transcript exists for this hearing, appellant requests that it be included in full. If no reporter's transcript exists, appellant requests that the record reflect that no reporter's transcript was prepared for that date. This is, the wording is, I'm not an expert in these. I've only looked at a couple of these in my life, but this wording is weird to me because she knows that there was a court reporter and she knows there's a transcript. So I wonder if it's just like, blanket text, but then why would you include it anyway? It makes it feel like it wasn't written by her. Um, and so, yes, this is the court reporter that Mike and Omar hired. And if we look back here, this is the, most recent stuff from the case. There's reporter's costs, and it says deposited by appellant Laura Owens. She paid $325 for this. And then there is a fee, and this is all on the 23rd of December. There's a fee to cover trial court costs associated with administering trust accounts for payment of reporters' transcript costs. So it looks like it's another, I'm not going to pretend to know exactly what it is, but it's another fee associated with the court reporter and requesting maybe the transcript. These things, I've seen some people online say, she didn't actually have to pay for these and she shouldn't have because she had the request to waive court fees and costs and that it was granted. Where does it show that it was granted? Anyway, it was granted. So anyway, that this stuff is not included in that waiving of fees and costs. This is additional stuff that she did have to pay for. So she did pay this $375. Well, maybe who gave her that money? Where did it come from? She just filed bankruptcy and says she has no income. Her parents filed bankruptcy and they only have $20,000 a month in income, but like you wouldn't think they'd be able to afford just giving their daughter like hundreds of dollars for these court associated things. So, we're going to get into the trustee application for the attorney and stuff like that, but that's just interesting. She was able to scrounge up $375. Maybe it was left over from that childhood savings she said she drained to buy the trip to Iceland. Anyway, then C, electronic record, requests that the clerk's transcript be prepared in electronic format. So that's another thing she wants there. So those are typical things that you would request. So again, we just need to see, if we look at this, the steps here again, we need to see what really, first of all, if the court is going to rule on her motion to correct and augment the record, which isn't properly before the court, but I don't know if she's fixed it and resubmitted it. We just don't see it on the docket yet because we know the docket can be really slow. So we have to see if anything ever even comes of that. Then we have to see the designation of record on appeal. If the court grants, everything that she is requesting in here, if this was even filed properly, that's another question, and I don't know the answer to that. It probably was, and it was filed timely at least, or what her attempt to file it was. Then we have to see again, like, does the court invite Omar and Mike to respond, or do they respond themselves? Or how do they handle all of that? So we have a couple steps before, like, we're actually going to see her appellate brief, and see what happens from there. All right. So I'm going to jump now to the bankruptcy case. I haven't gone over really much of this, but I wanted to go over the trustee's application to employ an attorney. I am not a bankruptcy expert. I'm not a finance expert, but I have spoken with some people who are. And while in a my understanding is in a really complicated bankruptcy case where there are like a lot of assets and could just be really complex, they they would hire an attorney. In a case that's pretty straightforward, they wouldn't really need to hire an attorney. Laura's case, if you just look at what she filled out, we're not going to go through all that right now because this is obviously very 63 pages. But if we look through what she filled out, she doesn't really have many assets. The biggest thing she claims is this vehicle, this Hyundai that she, has this loan out on and is upside down pretty much completely on the loan. She claims some horseback riding gear, glasses, her dogs that she says are worth $1. Anyway, here's anyway, it's pretty simple. Like she's not claiming a lot here. She's not including a lot. But there is something here or within the research that the trustee has done that has led them to believe they need an attorney. From my understanding, what I've been told is that usually deals with or comes from the belief that someone is hiding assets. I'm not going to claim to know that is what's happening here, but from what I understand, that's usually the main reason or a big reason why they would want to hire an attorney in a case like Laura's. So Eric Haley is the case trustee. The case was commenced by voluntary petition filed by the debtor, Laura, on December 8th. So that's when she filed this case. Remember, it was a day before her judgment debtor examination with Greg Woodnick, which we saw coming from like 1,000 miles away that she was going to claim bankruptcy. If she lost the paternity case, which obviously she did back in June of 2024. So let's go through here. Basically, I don't want to read the thing, verbatim, but let's see what Eric says. He says, or Mr. Haley. He wants to consult with the case, to advise and consult case trustees. So he wants to talk with the attorney about questions arising in the conduct of administration of the estate and concerning case trustees' rights and remedies with regard to the estate's assets and the claims of secured, preferred, and unsecured creditors and other parties in interest. I will say, Laura has a lot of, where is it here? Creditors. And she has 24 separately listed. These are ones that she listed out, creditors that she owes money to. And number one is Clayton. Here's the Hyundai that she owes money on. So that could be maybe just that reason in and of itself is that there are so many creditors that they wanted to get an attorney. But knowing this family, I would not be surprised if they were hiding assets. That would not surprise me. I'm not trying to say that they are, but if we find out that they are and they have, it would not surprise me in the slightest. To appear for, prosecute, defend, and represent case trustees' interests, so representing the case trustee, investigate and prosecute preference and other actions arising under the case trustee's avoiding powers. That's probably one for Tiff right there to explain. Basic assist in pleadings, motions. So it's like helping with different aspects of the case. I don't think there's anything too groundbreaking or exposing in here. So it just says for the foregoing reasons, I'm going to retain someone from Knock, Rogers, Hilkert, and Santilli. And then it names the person down here too. It says what their rates are, then that the rate can kind of vary based on their level of expertise. That's kind of what this talks about. And billing rates industry wide here. That's all about their compensation. Okay, so this number 10 says that the attorney has already done work on the case. So the trustee is asking for them to be compensated. They want them to be compensated for the work they have already done. So that basically it's like this can be like retroactive to cover, when from the date they first started working on the case. Then we have the declaration. Here is the lawyer from that law firm, Knock, Rogers, Hilkert, and Santilli, NRHS. Stuart Rogers declaration. Um, he says he's admitted to practice in Arizona and the Court of Appeals, Ninth Circuit. Basically, this is just stating that he's qualified. That members. He has extensive experience in bankruptcy, as does his law firm. They're well qualified. That they don't hold any interest. So basically, like you know, there are no issues on his end representing the trustee or the in this case. It says that they're going to work on it alone. That they have agreed to share compensation in this case with anyone except as professional fees are normally divided among other members of the law firm. So I think, maybe he may not be the only one. Obviously, I'm sure he's going to have help from a paralegal or two to work on the case. So, yeah, the reason I wanted to cover this is I think there are some, and I could be speaking out of my ass, but I think there are some red flags, at least a red flag, to the trustee that made them feel they needed to hire an attorney to help with this case. And again, here, I'll put all of these links in the video description. You can go through, if you want. I think there are breakdowns, even on, victims of Laura Owens. It's not extensive, like a small breakdown of her filing and what she has claimed. Here you see all of the different companies that she owes money to. But yeah, this is the Chapter 7 thing that she filed. And to point out, as we know, gosh, that was so long ago when she tried to submit a name change to change the name of Emily Laura Wilson, and it was she withdrew it. It wasn't denied, but she withdrew it because JFC, the community people, found out she had done it and she withdrew it. She tried to get her court fees back and the court said no. So anyway, it's really interesting to me to see this name pop back up. All other names you have used in the last 8 years. So, to me, it makes me think, well, what has she used that for? Has she used it to get, like, fraudulently to get credit cards? Why does she need to add this here? What has she used this name for? That is my question. And I really hope we get to find out. Okay, this is really long, and there are better people to go over it than me. Here are her assets. She says these are her assets. This is $19,950, which I believe also include that vehicle. These are her liabilities. This is her debt, $263,750.08. Yeah, so this whole thing should be fun. It seems that as of now, she has submitted everything she needed to. I think it was, what is it? These two documents, the Schedule C and current monthly income, were things that she hadn't filed that she needed to file in order for the case to move forward. So she did file those. So we will just have to see what happens with that. I will just touch briefly. I'm not going to go through. Maybe I'll do another video at some point, like going through the articles and all of the stuff on this site. Again, this is the justiceforlaura.com website that has popped up right around Christmas time, I think, when people really saw it. This site claims to be run by, it says, this website is operated independently as a public information and advocacy project. All statements, descriptions, and links are based solely on publicly available information, either current or prior, accessed from archive.com, court filings, and media coverage. No content on this site should be interpreted as official commentary, strategic communication, or legal positioning by any litigant. Uh, yeah. In these articles, it says Justice says the okay. So most, if not all, of the articles included here are from Laura's RAP old medium profile. And here it says Justice for Laura volunteer. I just think it's so funny that all of this time has gone by. This has been public for over 2 years now. And just all of the sudden, someone happened upon this and decided to make a justiceforlaura.com website and come up and support her and volunteer their time. It just like makes me cackle to think that she thinks anyone is going to believe that. And hey, again, maybe I'm talking out of my ass, and maybe it really is just a supporter of hers. My opinion is that, and I don't think I'm alone, is that she made this website, put everything on here. And I want to remind everyone here, if you have not seen this website, if you have, you know that this is here. We need your support today. Donate. Spread the word and donate. Let's see. I don't see any way here. And we have seen that she's made some updates to the site since she saw um online in a public chat room, probably, that people found this website and were pointing out, she had like a concert scheduled and a bunch of things scheduled that you could pay for, buy tickets for, whatnot, to go attend, and those things have been removed. Yeah, so I don't see any donation link here unless I'm missing it. Please let me know if I just am being dumb right now and, don't see the link. Let's join the movement here. Okay, that goes back to the homepage. So anyway, I had found this. Well, first of all, it's interesting just in and of itself. There's now a Justice for Lawrence website. When we have a Justice for Clayton website, we have a Victims for Laura Owens website. We have all the best research and timelines covering the case. It's, they have their own website as well. And now this Justice for Laura Owens, or Justice for Laura website comes about. That was number one in and of itself. Number two is the fact that they had donations. They have a place where you could, enter payment information and buy something. Now, I never even tried to go through the process. So I know with some of these sites, like, they can have those options, and maybe even with certain templates that you use, they might just have that innately, like, as one of the pages. I don't know if she actually set anything up on the back end to collect payments, but that would be really interesting if she did. And if she continued to promote this and collect payments, it would be interesting for the bankruptcy case. For lots of things. This only has 2 pages. Clayton Eckert and Michael Maricini. Wonder where Greg Gillespie is, or any of the other, Lone Cactus or PS Creative, Uber, any of this stuff. And again, she is just she is so butthurt about this Inside Edition video. Share it wherever and whenever you can. She hates it. That featured Mike and quickly exceeded 1 million views. Yes, it did. And I love that. News, contact, who's brave enough to fill this out? Who's gonna fill this out? So anyway, we have this website, justiceforlaura.com. Now, if you go to ICANN and look up any website, you can see some information on it. Now, people who buy the domains can pay extra money to multiple different companies. There are lots and lots of options out there to try to hide your hosting location, or try to hide your identity. And this person who has purchased this domain, justiceforlaura.com, has done just that. If we scroll down here, registrar information, she used, or whoever bought this, used Namecheap Inc. So we see Namecheap here. So instead of showing the actual owner's information, she has paid money to hide her identity, which a lot of people do. It's not, generally like a shady thing or unaccepted thing. Lots of people will do that. But I just find that interesting. Now, it also gives the mailing address as Reykjavik, Iceland, which maybe it just is that, maybe it's a coincidence, or it has something to do with Mike Maricini and Iceland. Maybe she's trying to troll people with that. Here, I wanted to copy this. Go to Google Maps here. I looked this up the other day. And we can see the location here. It's just this building. And now I know that these can have like random addresses and stuff. I know it's not, going to lead to like someone's house or anything. But I just find it interesting that it is Iceland and Reykjavik specifically. I know it's a big city. I know, but just the connection with Mike and that whole thing, that's what I find interesting about it. Now, I had also checked justiceforlauraowens.com. Now, I want you to look here real quick. So I'll delete this. This is just still for justiceforlaura.com. We look at the registry expiration, March 11th, 2026. So typically, I was going to say typically you can buy different lengths of time to purchase your domain name. A lot of times they'll offer a deal up front for 1 year, and you can get it for like really cheap. Usually like the subsequent years are more expensive once that time comes. Sometimes they're not, but sometimes they are. Anyway, so this person purchased this domain on March 11th, 2025. It expires March 11th, 2026. So if we take a look at, that's justiceforlaura.com. If we take a look at justiceforlauraowens.com, it's the same dates. Now, I'm not like, I discovered something like crazy. I just find it interesting. Registry date 3/11/26, that's the expiration. It was registered, created on 3/11/25. Updated. This domain was updated on 12/16/25. I forgot to see if this one was 12/13/25. Now I'm going to check something here. If we do justiceforlauraowens.com, it may not go anywhere. She may have just purchased it, or whoever purchased it may have just purchased it. If that person were smart, they would have it redirect to justiceforlaura.com. There's a little tip for you, not Laura. Anyway, these are the things that I wanted to cover. And like I said in my post from the other day, I have a thing or two coming up that I hope you guys will enjoy. And I can tell you without telling you specifics that we have a couple of things to look forward to in Mike's case. So just stay tuned for those. I hope you all had a great new year, and I'll see you again soon. Bye.
SchnitzelNinja!